Good afternoon. Well, good noon. I guess good precisely noon, everyone. Um, my name is Bruce Hornsby, and on behalf of the Law Society of Yukon CPD Chair, CPD Committee, I'd like to welcome you to teach Indigenous law today and tomorrow. The Law Society of Yukon's offices are located on the traditional territory of the Kwamandun First Nation and Tonquichin Council, as am I. The Law Society is committed to fulfilling its obligations under the Truth and Reconciliation Committee report. Although further work is being done on that, it's not as you're aware, reconciliation is an ongoing process. I would like to ask the people attending to reflect on the traditional territory from which they are joining us today, of the First Nations that they are joining us today, and the role each of us as members of the legal profession can play in ongoing reconciliation in Canada. Today we are very pleased to be very pleased and grateful and honored to be joined by Professor Val Napoleon and Professor David Millward from the University of Victoria. Professor Napoleon is Indigenous Peoples Council, Bachelor's of Law, Doctor of Philosophy, is the acting dean of the Faculty of Law at the University of Victoria, Law Foundation Chair of Indigenous Justice and Government, co-founder of the GID program, of the GID-JD program, which is the first of its kind dual law program in Indigenous and common law, and founder director of the Indigenous Research Unit. So he is Cree from Saltine First Nation and adopted member of the Gitnyao Northern Gitsan. Her areas of research include Indigenous legal traditions and methodologies, land, water, governance, and democracy, human rights, gender, dispute resolution, and intellectual property, legal theories, Indigenous feminism, legal pluralism, Indigenous democracy, Indigenous intellectual property. She teaches common law and Gitsan law and property and law transsystemically in the GID-JD. David Millward is an associate professor at the University of Victoria and a member of the Brady I knew I was going Kutamis. Sorry if I mispronounced that, David. I'm sure I did. Sorry about that. In Saskatchewan, he has authored 2 books: Indigenous Justice as Reconciliation and Aboriginal Justice and the Charter, and has co-authored The Art of Science in the Canadian Justice System with the late Dr. Charles Ferguson. He has also authored numerous book chapters and articles in leading international and law journals. Please join me in welcoming them. So we're going to proceed with the presentation, and then please do shoot questions in the chat of the Q&A, and we will get and those will be addressed at the end of Val and David's presentation. And I'm sure I do see quite a few people who like me attended UVic and probably had the opportunity to have the opportunity to have Val as one of the professors, or perhaps some of the newer people, also David. So thank you very much for joining this afternoon.
Good afternoon. Thank you so much, Bruce, for that introduction. And David and I are on the Lekwungen speaking people's lands, and those lands are still part of the Songhees and the Esquimalt and the Wasanic people's territories. So honored to be here. Thank you for this invitation. I have a PowerPoint, which I will now share and then introduce to you. Here we go. And so I wanted to introduce the other character in this session today, and that's the trickster Raven. She is Indigenous feminist trickster, born and reborn of Indigenous feminist consciousness here and from around the world. And so tricksters for many Indigenous peoples are the first law teachers. And so this is Grandmother Raven or Kokum Raven. And I was told a long time ago that people listen better if they have something to look at. So here you go. there's images of the raven for you to look at. So we have some of the slides, and then there's a general kind of overview to thinking about Indigenous law. And then we have some specific information about the Indigenous Law degree program, and then we're really hoping for your questions and conversation to lead us through. So, as you know, Canada has many Indigenous legal orders, and when thinking about a legal order, it's helpful to think on a societal scale, not small individual scale. And so every Canada and every other geographic space in the world has more than one legal order that exists in its space. The extent to which those legal orders cooperate, interrelate, it depends on the histories, and some are very successful interrelationships or examples of legal pluralism. Others, there are conflicts. And so that's the situation that we have in Canada, where geographic spaces have multiple legal orders. And one of the ways to describe Canada is as multi-juridical, because Indigenous law hasn't gone anywhere, but it's been undermined and often is invisible to people. So taking a really broad view of law, one of the ways that I talk about law is that it's a human endeavor that covers all aspects of collective human life. And so we think about law substantively, but also procedurally. There are legal processes that are legitimate. Law always operates through the legal institutions of the society whose law is operating. And the laws are a part of the political ordering of a society. They're part of and connected to the economy of a society. And they concern lands and resources. They concern water, family, governance, human rights, and so on. So the research initiatives that we work with through the Indigenous Law Research Unit cover all of these subject areas, and we work with Indigenous communities in partnership across Canada. So that's the overall sort of, like, what does law do? And so this is the starting place for that. And then in thinking about what is it that within the legal order, what's there, like what's required for it to be, for what are the legalities? And one is that law is always collaborative. It's not what one person says it is. It's always public, and this includes Indigenous law. I'm doing a talk next week in Dublin about Indigenous public law, so that there's private and public elements of Indigenous law as there is with state law. People have processes to figure out legal responses to problems, a range of problems. There are always authoritative decision makers, and that often who they are depends on the kind of legal problem that they're having to deal with. There's a range, pardon me, there's a range of legitimate legal responses to problems, and then there are substantive and procedural rights. There are obligations, and then there are guiding legal principles. So every legal order has these aspects to it. They will look different depending on the society, but the functions, the work of law is the same. So the work of law through, for the Gitxsan people operates through the matrilineal kinship groups and the clans and the feast system and so on. In the Cree society, it operates on a family basis, on a community basis. So it looks different according to the society, but the problems that law has to deal with are universal. And these include gendered violence, they include power imbalances. A lot of the oral histories concern abuses of power, for instance, in the Dene with the Dene legal order. So the approach to working with Indigenous law means centering what the Indigenous legal perspective is. And so whatever problem is being approached, whether it's building an emergency plan for dealing with floods for the Nicola, or dealing with water shortage, or other challenges that Indigenous peoples have, the starting place is to think about what's the legal issue from this legal perspective. So there's specificity to that legal order is absolutely required. The second question is, who are the authoritative decision makers? And then what are the institutions through which law operates? Because it doesn't operate outside of human institutions. And what are the terms of legitimacy in that society? Whether we're dealing with Dene law or Cree law or Gitxsan law or Tsilhqot'in law, there's going to be a range of legal responses to dealing with different questions, and there's going to be precedents, there are oral histories, there are stories, there are recordings of how people have historically dealt with issues. They can also be counter stories. So there's numerous ways to learn and draw from precedents of Indigenous peoples. There's a range of remedies that are contained in those precedents, the different kinds of precedents. And there's a range of sanctions that people have historically drawn upon and developed to deal with problems. And there are situations where there's more than one legal order in the same geographic space. So in northern BC, for instance, there's Dene and Cree peoples in the same spaces. And so one needs to think about more than one legal perspective and more than one inquiry into how to approach problems. And so that's some of the work that I've been involved with in the Northeast. The kind of legal problem will determine which the role of the decision maker. So for the example that is really helpful is to think about Cree elders, and the role that they play will either be persuasive or directive, depending on the kind, like whether there's community safety at issue or whether there's something else that doesn't quite is not quite so dangerous. So they'll persuasive or directive, and it depends on the problem. There's lots of other variations to this with other legal orders, of course. Gender is critical, and in all of the work that we do, it's something that comes up, whether it's with lands or water or governance. It matters and needs to be built into the heart of self-government. It needs to be built into the heart of how Indigenous peoples, how we treat one another. We need to think about the power dynamics. We need to think about whose voices are heard and who's rendered invisible. Why does it matter? Why does Indigenous law matter? One of the ways to think about law is that it's a way of seeing the world. It's a way of understanding problems in the world, and it's a way of ascribing meaning to our own actions and to who we are in our societies. Law is, you can't be a people without law, and you can't govern without law. It's an essential part of how we organize ourselves, how we manage ourselves through time. So that's the broadest kind of arc in terms of an approach to working with Indigenous law. And then, of course, what we have to do in the JID program is get into specific areas of law from different legal orders.
Hi, everyone. So here's where I'll jump in and give an overview of the JID program. So first, I'll start with a sort of a comparison to other law schools, possibly accepting McGill. In fact, we actually drew a little bit of inspiration from the McGill joint degree in common law and civil law, but we've also gone off in our own unique direction. So in most other law schools, during your first year curriculum, you're learning your basic subject, criminal law, contract law, torts, property, and they all get taught in their first year, but it's a focus is squarely on a Canadian common law legal order. And it's not to say that there isn't value in that. In fact, the students do actually learn a lot. But in here, as part of the Victoria program, what would normally take 1 year, we actually take about what would be the equivalent of a year and a half to complete. And then during the second year, students will have some room to take some optional courses. But during the first year, there's 3 required courses: transsystemic criminal law, transsystemic constitutional law, and transsystemic property law. And they're taught over the course of a full year. Now, the reason why we only include those 3 subjects, there's a number of reasons. One is that we're also teaching legal process and also legal research and writing. And those are both obligatory courses during the first year. So we have to leave some room for those. But during these 3 courses, we're also learning, for example, in constitutional law, John Burroughs teaches both Anishinaabe law and Canadian constitutional law in the side by side. Now, I've listened to a few of his lectures on Anishinaabe law, so it gets into some really deep metaphysical things like Anishinaabe worldviews, but also some contemporary and Anishinaabe efforts at writing constitutions or creating constitutional instruments for their own communities. Now, Val Napoleon teaches a course that emphasizes both Canadian property law, but also Gitskan property law as well. Mind you, we do have to be a little careful about labels like calling things property law. So I'm sure Val will be the first person to say Gitskan property law might be a bit of a misnomer, because Indigenous legal orders sometimes didn't have these neat divisions between Canadian law, criminal law, constitutional law, property law. The legal systems are very often a holistic emphasis, but I do believe Val takes components of Gitskan law that at least share parallels or comparisons with Canadian property law. And the value in that exercise is sometimes, even when it comes to understanding Canadian property law, sometimes you understand something better by holding it up against something that's not quite the same. So, for example, in my own course on Cree law and Canadian criminal law, there's a lot of differences. Like, for example, Canadian law hesitates to put a general duty to assist on people, but Cree law very often does. Or Canadian law likes to build this distinction between regulatory offenses and true criminal offenses. And regulatory offenses, it's okay to kill fish or kill animals because it's not a true criminal offense. But a lot of Indigenous legal orders will actually say doing things like that improperly actually does elevate to a true criminal offense subject to punishment. Now, in the second year, we can continue with transsystemic courses, but unlike the first year courses, they're only over a semester. So we're leaving students some room to start taking some optional courses in the second year. So we have Chilcotin law and Canadian contract law, which is often taught by Alan Hanna. And we have Coast Salish law in Canadian tort law or civil law. And that course is frequently taught by Sarah Morales. Now, we also have a couple more courses. One is a transsystemic, intersocietal, and administrative law. That's often taught by Jana Promise Law, where there's often a comparison between Canadian administrative law and Haudenosaunee law. And in transsystemic business associations, that's often taught by Rebecca Johnson, who's teaching both about the division between the shareholders and the executive officer and the articles of incorporation, all those standard features of Canadian corporate law. But she's also at the same time teaching how Indigenous legal orders often handle similar things. So she often draws on Inuit law and Dene law and so on. Now, the reason why our program is 4 years instead of 3 years, and it is a significant commitment to take on 4-year program instead of a 3-year program. There's 2 reasons. One is, again, the way that our transsystemic courses are structured, we do have to spread that out a bit over what would roughly amount to 1.5 years. But the other reason is that we also have our field schools. So the concept or an idea behind a field school is that students actually reside in Indigenous community. And the idea here is that while they're in law school, they're learning about law in a certain way. They're taught cases by their professors. They review statutes and statutory provisions, and they read cases, and they prepare legal memos, and they take written examinations. So the conventional law school pedagogy, and not to say that there's some value in it, but the point behind the field schools is to inculcate students in a certain different way of thinking about law that's inherent in Indigenous legal orders. Now, that's not to say that we don't do this during the first couple of years during our transsystemic course. So, for example, I bring in a Cree elder named Daryl Mills who holds a circle for students, but that takes up one class. The point of the field schools is to take it from just that one, perhaps token sampling, and to really take it to the next level where students become a part of community life. And they get to experience law not just as words on a page, cases or statutes, but they learn to appreciate that Indigenous legal orders are not just things that you talk about once in a while, read about once in a while, but it's an actual lived daily experience from the moment that you get up till the time that you go to bed. And so the other thing is that we want these field schools, we try as much as possible to make it a mutually beneficial relationship. So it does require a commitment on the part of a host Indigenous community to actually provide the students with learning experiences and to put up the students and to accommodate the students and to take them out on land-based learning activities or to have elders instruct them. And we do recognize that we are asking a significant devotion of time and commitment from a host Indigenous community, but we want to make that mutually beneficial. So very often, the students themselves will undertake work or projects that are intended to be beneficial for the host Indigenous community. So maybe, for example, a host Indigenous community wants to explore what they can do by way of preserving their cultural property. So they would like some research work done to that. Or maybe they want to develop and draft bylaws for their own child welfare system. So maybe that's a project the students can work on. I'm just, throwing that out as possible examples. But the idea is that the work that the students do is not just for their own learning, but it's also there to be beneficial to the Indigenous communities, to honor the Indigenous communities and to show gratitude to the Indigenous communities for themselves providing their knowledge and learning to the students. So that's a relatively brief summary of the JID program. And at this point, there's nothing like it in the world.
So we also, this year, our first graduates crossed the convocation. They convocated, and so they're heading out into the world. I think four of them are going to the Attorney General, and 5 are going into different levels of courts, and others are going into private practice with different firms. And there's a couple that aren't sure about what they're doing, and the one just had a baby, and the other is still, determining how she wants to go forward. So they're out there, our first graduates. We're really proud of them, and we now, this September, our 5th cohort will be starting in September. So the law school now has, as of September, we'll have close to 100 students that are part of the Indigenous law degree program, which means that our building is quite crowded. But and we're building in addition to the law school to expand so that we can make sure we have classrooms and ceremonial spaces and other kinds of things. I wanted to just add to what David said about the field schools. So one of the field schools was students worked with a group of communities in the interior. And we always hire someone from the community to work with the professor. And the focus that the community chose, their priority was child welfare. And so they divided up the work into work with teams of students. So there was a students that worked with the appeals, there were students that worked with institutions, there were students that worked with precedent and so on for this scope. And at the end of that, the 14 weeks, the students presented their work to a full auditorium of people from all of those communities. Community members asked questions of each team about the work that they did. And what we were told was that the work over the 14 weeks that the students did saved that community, those communities, 3.5 years of work. So when David talks about benefits to the communities, they're real, they're material, and that's part of what we're doing is we want the students to see how important engagement, serious engagement with Indigenous law is, and what difference it can make to the communities that we work with. So there's, that's the idea of the field schools. Darcy Lindbergh, our Cree professor, another one of our Cree professors here, in one of his papers asked, what if all the stars mattered? And it was a question, for Canada, what if all the legal orders mattered? And I thought it was just a beautiful way to frame that question. And this picture, which I found and have permission to use, by the way, it demonstrates how we can learn to see law in another society. So I mentioned earlier that law is a way of creating meaning for us. They are also laws, different legal orders. They in of themselves form grids of intelligibility. So they determine what law we see or don't see. And by that token, the grids of intelligibility that we have, like if it was only Canadian law, it makes other laws invisible. So the work is about Indigenous law as law, and having to do the work of law. This is the last slide, second to the last slide. There are lots and lots of really important and beautiful conversations about Indigenous law from lots of different disciplines, political science, social work, philosophy, and so on. But when people get in trouble with Canadian law, they want a lawyer. They want somebody able to practically engage with Indigenous law. And so we need to think about Indigenous law in that same way, that we need to be able to solve problems with Indigenous law by drawing on processes, by serious engagement, thinking about remedies and so on. We have to take it seriously as law and have expectations and be as critical with Indigenous law as we are with any other law, Canadian, civil, whatever. So that's really important. I just kept this slide here because this shows those of you who graduated from UVic. This is the current entrance into the law school is replaced with this whole addition. So it starts out front here and wraps around the building, and it goes from single story to 2 stories. It has lots of space and air and glass and so on. So it will be beautiful. We're going to have a ground blessing ceremony in October to actually start the construction. We've had open houses and lots and lots of consultations to get to this point. So the prep work is done and construction is next. And we wonder if there are questions. And with that, I'll stop sharing so that we can all see each other. So stop share.
Thank you. We have a question from Rick Buchanan. Professor Napoleon, I work with a variety of statutory or adjudicative tribunals, both under the laws of general application and First Nation self-government laws. Indigenous citizens can potentially be participants before these tribunals. Some tribunals have formal rules of procedure, while others operate according to general common law procedural principles. Most, however, have no express provisions to accommodate and respect various Yukon First Nations legal traditions. Can you offer some thoughts on how tribunals might integrate into their procedures indigenous traditions, ceremonies, or values in a way which may be consistent with the laws of general application and/or statutory principles?
So thank you for that. This is one of the areas of concern for the province of BC, who are, past DRIPA to incorporate UNDRIP into the laws of British Columbia, and there's been quite a concerted effort to begin figuring out a process of looking at legislation and regulatory processes. And so I've been doing a series of workshops with different government ministries to get the conversation started. So one of, what I've been suggesting to the province is that we choose a pilot area, like an area of law. We look at the different legislation and other legal processes emanating for that one area of law. And then we systematically begin looking at what would the law from different legal orders in the province say about how that issues are defined, how the consultation happens, how decisions are made. And so that it's a matter of drawing the wisdom from more than one legal order to figure out a legal response. One of the ways that McGill works, what they call the transsystemic approach that David was referring to, is they identify the human problem that's before people. They identify the doctrines which would apply to that problem. Then they look at the context and the processes which should inform the application of the doctrine, and then from that figure out how to go forward with changes, amendments, and so on. The other approach, which we have been doing some community workshops on, is legislative drafting, but drawing on the reports that are prepared. So for instance, we have Asuna-Uchi-Winnewak in Alberta has reports on, done by Hadley Friedland on Cree law. And what we've been working with communities on is to take those laws, the laws themselves, the principles, and then look at drafting, and then to look at each phase of that legislative drafting in a way that actually reflects the Cree law itself. The trick here is that the homework, insofar as articulating substantively and procedurally Indigenous law, that homework has to be done so that there's something substantive to draw on in order to do either the drafting or the redrafting or whatever. So that there's some systematic, there's a critical and systematic way that people can engage in the work. So that the homework has to get done, the homework with Indigenous peoples. One of the things that, and then I'll shut up, one of the things that I hear and have been pointing out to people is that there's so much demand for Indigenous law from communities, but there's little in the way of support to those communities to do the research of rebuilding their legal orders. That has to happen in order that Indigenous communities can respond in a meaningful way to the different demands that are being made upon them.
I'll add a little bit of a comment. It may not necessarily, it's more of a generic or broad stroke reply. It's not necessarily limited to administrative law, but there have been times where Canadian courts and so on have tried to incorporate Indigenous legal or try to engage with Indigenous legal orders on a meaningful level. But it's the results, although well-intentioned, sometimes leave cause for concern. So our colleague at UVic, Alan Hanna, wrote a good article where he expresses profound skepticism that about whether judges truly can engage with Indigenous legal orders, that they may not be capable of understanding it. So an example that I sometimes discuss in class is the Eterlikak case, where Justice Bychok, although he used Inuit law in a way that purportedly justified a provincial jail term instead of a federal penitentiary term, and he is right about Inuit law to the extent that separation of someone from his family networks would be just devastating. But then he saw sort of a harmonization between Canadian frequent use of Canadian imprisonment. He saw a harmonization between that and Inuit use of banishment. Now, my understanding is that a lot of Inuit communities, not necessarily all, but a lot of Inuit communities did use banishment, but they were sparing about it because in the north that it was practically death sentence. So it was very often reserved for the most serious of things. So when Canadian judges and so on try to engage with Indigenous legal orders, there's a tendency to look for points of similarity, to try and harmonize what they want to do with a perceived similarity with Indigenous legal orders. The concern there is that harmonization, if you actually properly understood the Indigenous legal order, sometimes that possibility of harmonization, it just isn't there, but it's forced anyway. And that's sometimes a question of why sometimes Indigenous legal orders just want to do things as their own independent legal orders without necessarily being strapped onto Canadian legal process. Not saying it's impossible, but sometimes the question becomes quite complicated when you consider all the nuances.
There is another way to think about it as well, which is, Justice Gramond, Sebastian Gramond, and some other justices are taking to the lower court, which is to draw on articulated Indigenous legal principles to inform decision making, so that so it's refusing to look at Indigenous law as a fact or as evidence, but rather as a way to inform the court's reasoning processes insofar as determining responses. So there's a line of courses or cases rather that are pretty important, and I think will increase in importance. And again, like part of what David is saying, what our colleague Alan has written about, is going to depend on the people and the issue, because we know that there's a huge range of possibilities, and it can't all be treated as one approach. Bruce, I noticed another question in the chat. Do you want me to? You're muted. David or Bruce, you're muted.
From Drew Milton, is there any nascent intention to bring back something like, I'm assuming that's the Kitsurat program? Looks different than I've seen it spelled before, but correct me if I'm incorrect in that, Drew. To enable Indigenous leaders with too many responsibilities at home to attend at Victoria.
So there was a second Kitsurat program just completed with in cooperation with the University of Saskatchewan. And basically those are courses in common law. They're the 3-year courses in common law with some additional material curricula that are added to them. We haven't, we're not in a position right now, having only just graduated our first cohort, to begin thinking about that question of more mobility insofar as the entire program itself. So it's what we really encourage busy people at home to do is to find ways to step out of that busyness, because all of that busyness will continue while we're in law school. And then when you go back, all of that work is going to be there. So, I mean, that's one approach. I know that there are lots and lots of amazing people out there who simply can't step out of the work and the responsibilities that they have. But we're not in a position right now to make the entire program mobile. We're working with the field schools right now.
Okay.
I'll add a little more to that. I do appreciate the idea of a mobile law school, but we have tried things like hybrid, where there's an option to come in by Zoom and so on. And sometimes we've done out of necessity, particularly as the pandemic was going through its last waves, or sometimes a student had a particularly stressful situation. Our experience has been that the student had a worse experience compared to being in the classroom on a constant engaged basis. So I do sympathize with perhaps the desire for some sort of flexibility, but at the same time, it's hard to get around that pedagogically. In our experience, it's not quite ideal.
Okay. How does the principle of extraterritoriality overreaching apply in the context of overlapping Indigenous laws from Pippa Lawson?
So, so I mentioned that there's more than one legal order in any given geographic space. From a Dene or a Deniza perspective on this question, there's a responsibility when meeting a people who are different to explore whether those new people and what they're doing is dangerous. If they're not dangerous, then there's legal obligations within Deniza law to figure out how to live together. And that's all set out in terms of the approach there. In terms of where there's danger or conflict with new peoples, and then there's other legal obligations to figure out how to live together separately. I give a Deniza response, from where I'm from, which is, looking at Cree and Deniza law, because that's one Indigenous approach to dealing with how to deal with differences in legal orders on specific problems. What I would encourage here is that it's really important to be specific about which legal order. It's really important to be specific about which legal problem is at issue here. We wouldn't necessarily approach a question asking about Canadian law writ large. We'd have to be more specific in order to be able to research it, to figure out a response, figure out the legal issues. And we have to have that same kind of specificity when it comes to Indigenous law. David, I wonder if you want to respond to that.
One thing I'll say is sometimes Indigenous peoples could be fiercely territorial towards each other. So in my own class, I teach the story of a Blackfoot warrior and a Cree warrior fighting each other at what is now known as Wetaskiwin. And they're actually trying to set the boundary. At some point, they tire each other out, so they sit down for rest, and they share a pipe. So they smoke on the same pipe together. But they realize that act of sharing a pipe, that's actually a treaty sealing act. They didn't necessarily intend it to be at that moment, but chances are the Blackfoot warrior wanted to push the boundary north. Chances are the Cree warrior would have wanted to push the boundary south. But to not continue fighting and not respect the agreement they just sealed, it would have been disrespectful to the pipe and the act of sharing a pipe. So it just goes to show that sometimes Indigenous peoples did have this idea, this is my territory, you stay out of it unless we give you permission as a guest. Another one is that I would say that not all Indigenous peoples are even okay with Canadian law overarching their own legal system. For example, the Haudenosaunee many Haudenosaunee still regard themselves as an independent nation state, and the Longhouse is their governing authority, not the elected Bandon Council. And to them, the idea that the Canadian United States border stretches over part of their territory, it's something that they just don't think is important, or it's an encumbrance to them to be circumvented if and when it's necessary in their interest to do so. And in fact, a lot of Indigenous legal orders, they sometimes try to operate under the table. So sometimes Indigenous peoples try to resolve their own disputes in ways that hopefully it doesn't get brought to the attention of the police. They don't want Canadian criminal law to apply, so they try and deal with it quietly and amicably and hope that it doesn't come to the attention of Canadian authorities. The reason I'm getting those points is, I mean, some Indigenous peoples might be okay with some sort of shared powering agreement or some sort of shared governance, something like give and take, but you can't make that assumption in broad strokes across all Indigenous people. Some Indigenous people still have very quite nationalistic sentiments where they just want it to be just their Indigenous legal or not have any application for Canadian law. So it depends.
And yeah, just one thing I would add in the more modern context is in Yukon, of course, Yukon First Nations have agreed to 3 ways are under the self-government agreement that they'll apply. One is just to maintain title lands. One is to traditional territory, and then the third is applies to citizens wherever they are in the Yukon. So it's a bit of that agreement to where there's an extraterritoriality under what will be laws that will be heavily influenced by Indigenous traditions. I don't know that to my knowledge, I don't think any have been enacted yet, but it's there in the toolbox and will be something that will come up.
Mm-hmm.
Paul Seaman asks, Professor Burroughs, or maybe Statesman asks, Professor Burroughs once used a wonderful analogy of Indigenous law being the land obscured by buildings and development in Toronto. I think his point was that the legal system is still there, but remains obscured by colonial constructs. Given the reality of the division of power and the common law being in place to provide de facto authority to the crowns, what is the best and most practical way to give Indigenous laws normative force, including providing substantive remedies within the colonial system rather than limiting their use to historical evidence? For example, the purpose of proven title, is Section 35 interpreted as a full box of rights enough, or to do this, or is legislation needed, i.e., things like Bill C-92, and as well, and drawn on Bill C-92 as an example, how can provinces and the federal crown be required to recognize these systems should have taken onerous, unarguably impossible measures of national constitutional amendments?
So I've talked about this in my new book. Indigenous Justice and Reconciliation. It's published with Fernwood Press. I do have my own hope that at some point Canadian legal system actors and politicians can at some point see the merits of Indigenous legal systems, and sometimes there's alternatives that work better for Indigenous peoples themselves, and therefore they have to let go of that jurisdictional and legal space to let Indigenous peoples do things their own way. Now, at the same time, it's not all Indigenous peoples perhaps share that guarded optimism that I have about that actually happening. So, for example, it's a name that perhaps all of you may have heard at some point, Glenn Coulthard, and also his former mentor, Daiki Alfred. They're both quite big on this idea of the politics of recognition, the idea that, trying to get into that shared understanding of the Canadian legal authorities, that's just a recipe for continued colonialism. And Indigenous peoples will just put themselves into some sort of cognitive trap where they think they're making progress, but they're just really trapped in colonialism all over again. So the view is that we just have to do things our own way, unilaterally assert our Indigenous legal orders and go our own way. That's not completely fair to Coulthard and Alfred, but it's just a way for me to give a nutshell breakdown of that they're quite different viewpoints. So like I said, again, you can't reduce all Indigenous people to some sort of monolithic belief.
So I also think that it's really important to not only think about enforcement, like Canadian law doesn't exist by virtue of its enforceability. It exists because people understand Indigenous law to exist. It's in the world, and our informal understanding of law enables the formal understanding to be a part of our world. So one of the big challenges for Indigenous peoples and Indigenous law is, certainly this question, but back up from that question in terms of what will it take for Indigenous people to re-internalize our own Indigenous laws in terms of, responding to and upholding the norms, those concepts of right and wrong in our communities, right? So there's the work of rebuilding Indigenous law. Yes, there are all the formal processes that have to go on with the different levels of government, and people are doing that in a lot of different ways. But there are also all of the informal ways that need to go on, where people need to reclaim the language of law and engage in the fact that as Indigenous peoples, we are legal agents that are responsible for our laws. That it really, like, unless that happens on a citizenry basis, the talking about it, the formal talking about it, isn't going to have any traction, right? You need both ways to work with this. For specifics on how, on a group that's done a lot of work with Bill C-92, visit the Wahkotowan Law and Governance Lodge at the Faculty of Law at the University of Alberta. Hadley Friedland has been working with communities in Northern Alberta on this very topic, and would have and has resources for folks to be able to draw on. So I think that that it's really important to take these tasks and to break them down, and to, in doing so, expand what we think law in the world is, because it isn't just the formal stuff. One thing, there was a note in the question in the chat about whether we would be offering a one-year course-based JID option. We are looking at instituting a one-year LLM, course-based LLM, that with a focus on Indigenous law. So that's something that we hope to make available, not this year, but in the next year, available to people. We also have 1 month intensives. This year we offered 2 1-month intensives. They're over the month of May, they're full-time. We have a lot of practitioners from across Canada and the US and elsewhere who take those intensives on Indigenous law.
Okay, thank you. Question, James Struders. Hi, David and Val. Thanks for the great presentation, and thank you for taking the time. I'm seeing more and more tension between skepticism of colonial legal orders and communities, and as a legal practitioner, I also see ways in which existing structures, for example, land codes, which essentially replace the ISC legal authority and dealing with reservation lands and grant civic lawmaking power to the nation, as well as resources for support of the creation of administration of these laws via the LABRC, could be expedited to recognize, adopt, and codify Indigenous legal orders. Do you think existing frameworks play a role in the way forward for recognizing and rebuilding legal orders?
I'll start with that. So I know some of what you're talking about, like, for example, the First Nations Land Management Act. And again, like I said, personally, I do have an optimism, some sort of guarded, cautious optimism. Maybe even optimism isn't quite the right word, some sort of hope that more and more of these SRS can provide a space for Indigenous legal orders to do what they need to do. Mind you, I'm trying to make a push in the hardest area where it actually is, where Canadian authorities are the least likely to show any bend, and that is criminal justice, because it's good politics to promise bigger jail terms and everything else. And that runs counter to what a lot of Indigenous communities might actually want to do. So, I mean, things like restorative justice or circles, community circles, or any sort of other initiative where there's a real search for alternatives to incarceration, that runs counter against the law and politics agenda that a lot of Canadian governments continue to display. And despite the window dressing, I don't think even Trudeau has gone really that much of a distance from Stephen Harper, to be quite honest. So I do have some sort of hope, but it's not, but I'm also a realist. I'm not exactly holding my breath. So I do see some hope or some sort of optimism for it. But at the same time, like I said, a lot of other Indigenous peoples will have quite a different, even more pessimistic view of things. Val, did you want anything to add anything?
Yeah, for sure. I think, again, what I said earlier is that the homework has to be done. And Indigenous communities need to be supported to do that homework. When we think about land codes, like which legal order, what principles are going to be drawn on to inform a land code, like that homework has to be done in terms of what are the, say, for the Gitxsan forms of ownership, Gitxsan forms of dealing with inheritance, Gitxsan principles regarding marriage and access. Like Gitxsan law has a full scope of laws to deal with the stuff of the world, whether it's land, whether it's other forms of property, or whether it's intellectual property. And so, that, when something is articulated, then you can look at how will it be useful, or how will this framework be useful or not, or what has to change with the framework. But the homework has to be done in order to make that kind of informed decision. And there are folks, like in Ontario and elsewhere, who are looking to draw on Anishinaabe and Cree law to inform land codes, to inform housing policies, and so on. And the other thing which I will just direct your attention to is this book. It's it's edited by myself and two colleagues, about Indigenous property. And this is what's currently being used in Ontario to deal with the question of land codes, for instance. But there are others. Indigenous peoples are really, really pragmatic, and will, have found amazing ways to make sure that the legal obligations that they have according to their own societies are a part of whatever structures they have to deal with, in order to relate to either federal or provincial governments, or in order to create new relationships. The Haida are doing incredible work in this regard. Folks in the Northwest Territories, similarly, looking at agreements in order that are informed by more than one legal order. So there are lots of examples. People have been working hard. So there's examples to draw from.
Thank you. Question from Philippa Lawson again. Is it acceptable in any Indigenous legal order for the Indigenous legislation to create legal obligations on non-Indigenous people outside of the Indigenous territory?
Okay, I'd say it's been a real challenge just to make Indigenous law applicable to non-Indigenous persons inside Indigenous territory. Even going back to colonial times. Now, there's this general principle of international law that your law applies to your own people within your own boundaries. And when you go out and leave the territory for someone else, well, what that person does, that's that other people's business. And if they misbehave on someone else's territory, well, then you take a hands off. That's not for you to interfere with. That understanding also extended to to a very real degree to Indigenous communities amongst themselves as well. But ever since Europeans first arrived in the Americas, it's been a real challenge for Indigenous peoples to hold non-Indigenous visitors to account when they do something within their own territories. Even from colonial times, 18th century and onwards, English treaties, the Confederate and Atlantic treaties, would often have the stipulation that, well, if an English person does something on Indigenous territory, English law remains applicable. Now, those same treaties left it to when Indigenous people did things to each other, that's their business. But when one of ours is accused of doing something on your territory, English law remains applicable. And same thing with the number trees. You can make a case that the number trees actually recognize Indigenous jurisdiction over their own conflicts. It's an even more telling story when you look at the United States, where they have the tribal court system. Now, the starting point for the tribal court system is that you have the inherent plenary jurisdiction, that only Congress can enact laws that reduce inherent tribal court jurisdiction. Instead, Congress has used that in a number of ways, and there's also numerous United States Supreme Court decisions. So Indigenous peoples, they can't apply their own they're not allowed to apply their own tribal laws when a non-tribal member comes onto their territory and does something. And that includes even if it's a member of a different tribe coming onto your tribal territory and does something that you might want to invoke a punishment for. So tribal American Indian tribal governments have complained for years that this is just an unworkable motley of jurisdictional gaps. So in some ways, I don't mean to dismiss your question, Philippa, but there's a degree to which the question itself is a non-starter, because it's just, we can't even get anywhere in terms of Indigenous legal orders applying their own laws when visitors on their own lands.
And as a side note, interestingly, the Supreme Court just basically came down and said, United States Supreme Court basically came down and said, anyone can prosecute non-natives for crimes on native land.
Mm-hmm.
And quite controversially today, but yeah, total side. Anything more to add to that one?
No.
Oh, okay. Richard Smith asks, Rick Smith, Yukon. Some 20 years ago, as part of tripartite negotiation process, Canada, Yukon Testing Green Council, in which we were trying to give effect to the administration of justice contained within the TDC final agreement and its accompanying self-government agreement. We were looking at a way to establish a Tasman Clean Council plan-based court to administer justice, administer regulatory level offenses on Selma land. We even considered whether these courts could administer criminal code offenses, something we viewed as possible. Unfortunately, the 2-year process came to an unsuccessful end when Canada suddenly refused to fund the court endeavor. This was my first experience of the possible interaction between Canadian law and Indigenous law. My question is, in teaching about Indigenous law in your JID program, do you foresee the creation of an interactive legal process on traditional territories or Selma land in which Indigenous legal law and common law can substantively inform each other?
Yeah, good question. Now the thing is, it goes back to the questions that I've raised about compatibility and harmonization, where it isn't there. When you do see that sort of initiative where, oh, well, Canadian law is welcoming Indigenous input in the processes, even things like sentencing circles and Canadian law and GLAD-2, very often, incarceration sentences, prison sentences are the course of the day. And this is a point that I actually make in my own book. The Canadian justice system is fundamentally tilted towards a mass incarceration for a large breadth of offenses. Even things like a slap across the face could potentially land someone in jail, depending on how things play out in a court case. And then you have Indigenous legal orders where there are, not always, but there's a strong preference for a lot of things dealing with it in ways short of jail. So when you can talk all you want about, oh, the Canadian justice system and the Indigenous legal orders kind of come together, and they, I do agree that at some point you can't just suddenly throw out the baby with the bathwater overnight, but at some point you do have to wonder if the incompatibility is to such a degree that at some point Canada just has to let go and let Indigenous communities do their own things in their own space and where it's Indigenous law. applies to this and not Canadian criminal law.
So the challenge again is that, part of what I see happening a lot of is people declaring law at each other, either between Indigenous peoples or to Canada or to the provinces or territories, so that as opposed to saying, here's the range of law regarding this area, here's the range of way we deal with things, here are examples of legitimate decision-making processes that we have worked out. Here are aspirations of our law, which include safety, which include fairness, inclusion, legal agency. These are what our laws are aspiring to. And these are the same kinds of aspirations that Canada has. But my point is like to where Indigenous peoples have to get to with the rebuilding of Indigenous law is away from reacting as, like to instead of reacting to whatever is coming down, that we do enough of our homework. And this is what we have to support, that people can be in the lead and they can say, here's how we're, and we do see this. I mean, people are using our Indigenous law reports to build environmental assessment processes. This has gone on in 3 parts of the province. We're building emergency preparedness plans for floods based on, Indigenous water law. We're building Indigenous water management and stewardship plans, again, drawing on Indigenous law. There's other work that's going on to inform, child welfare processes. So people, are finding ways to put into practice the way that they want to manage themselves and different aspects of their lives. But that's the whole thing. Like as that work and that homework, whether it's dealing with sexual assault or dealing with domestic violence or dealing with other kinds of safety issues in our communities, like that, ultimately, we have to get out in front with those issues. And one of the things that I believe is that one of the reasons we have such high incidence of violence against Indigenous women and girls in our communities is that there's been an undermining of our legal responsibilities to one another. We've always had to deal with these issues, but the way we've dealt with them has been undermined. So there's spaces of lawlessness that have been created, and Canadian law has failed, which contributes to those spaces of lawlessness. And vulnerable people suffer in those spaces of lawlessness. The work then about rebuilding safety is to rebuild Indigenous law, to rebuild our obligations to families, to the vulnerable, to everybody who's a part of our communities, and to involve all of those people in that rebuilding process. So I'm saying step way further back to create safety in our communities. We need a bigger picture, not just reacting to aspects of the Canadian legal system and its failures to Indigenous peoples. We need a bigger picture to deal with.
Thank you. Darcy Kachuk asks, what, if any, links or opportunities do you see involved in restorative justice efforts made in Yukon or other jurisdictions?
So
go ahead.
I'm going to start this one, David. So I think that there are connections that people have found and people have continued to work on. Restorative justice is one of those areas that people have found within the existing justice system so that they can act on their obligations to one another. So it's one way, but it cannot be equated with Indigenous law. It's not Indigenous law, right? So, but it's a response it's a response to particular problems, usually criminal justice problems, that people have found a way forward with. So I think that there are lots of links. People have been doing amazing work with Gladue, but and the most important work are those that find connections with Indigenous law to inform what that work is. Restorative justice in and of itself is an important initiative, but it's not one that I recognize as being Indigenous law. And I think I have a different opinion about that than from David.
Yeah. So I do agree that there are some opportunities. And in fact, there actually are some initiatives. But for example, I do know in Yukon and in the other territories, you do have, for example, elder advisory panels, which is a restorative justice effort. It provides input to the court. But this is also kind of the point that Val's getting at. Those elder advisory opinions, it's exactly that. It's an advisory opinion. So it's still up to the judge to make the final decision. But whereas if it really was an Indigenous legal order, what the elders would want, that actually would be the resolution. It wouldn't be any more of a question of a judge overturning or a judge overriding the elder advisory panel. So that in that respect, that actually is the fundamental tension.
I want to thank Erin Linklater for her kind remarks in the question and answer. Thank you, Erin. It would be wonderful to see you and visit with you sometime.
Yeah, I just skipped over Erin's post because I was thinking that was a good way to close. Would be a good way to close to read Erin's comments. But I'll give maybe a minute to see if there's anyone else who has questions, and if not, I'll just read Erin's comments out loud as kind of the last word on this, because I think what she said is excellent. Okay, thanks everyone. I'm going to read Erin's comments. Erin Linklater, I want to just say my heart is so happy to hear about the GID program and Indigenous law work that has continuing to continue, and Indigenous law work that is happening. I'm so proud of you. I hope the Yukon Bar will give space and make support for Yukon First Nations and this Indigenous law work, that we can be supported through funding for this critical work for our people that have endured so much under Canadian law. And I just think, yeah, I just think that's so wonderful and pertinent to the work we do here, and what is real and actual reconciliation in Yukon and our duties members of the bar. So with that, I'd like to thank all our members for coming. Your attendance is what makes CPD like this a success. Extend our gratitude to David and Val and Val for coming, for making the time to do this over lunch break. And I know with teaching, it's a very heavy thing, and we'd all been looking forward to this for a long time, and I think this is a very good first step into doing a lot of that work that Erin was talked about. So thanks everyone.
So we're going to be up in the Yukon, our team through the Indigenous Law Research Unit. We're going to be up in the Yukon at Whitehorse and at Dawson City. And so maybe there'll be opportunities to connect, Bruce. Thank you so much.
Sounds great.
Yeah, thanks so much. Thank you for your interest.
Thank you.